that would eventually become issues in the trial, then he may not have examined for it, and he may not have documented it. And then it became an issue later on. However, I will say this: I've had many homicide trials, Johnny, and experts like any other lay witness. They come to you with varying degrees of communication skills. I've had medical examiners who don't communicate very well. They do their job well, but they simply do not communicate well in trial. And then others who do their job poorly, but can communicate well in trial. And a lot of times, testimony in trials it's about perception and how you communicate. It's how you say it, not so much what you say.
And I think there's so many sub issues in this case. And the other night when we had the forum over at the Miser Center, Perry Thurston had on his he was the moderator, he had on his little notes, fundraising. Well, fundraising was important in this case. And I read online today that George Zimmerman has now rolled in about $400,000 from persons donating to him because of sympathy. So in America, most persons of African descent cannot afford to hire persons who write these type books. But we called in this gentleman who doesn't speak effectively. And so I think that this adds to black folk and other minorities feeling as though they can't get a fair deal in this judicial system.
I'd like to throw out this question, and you can incorporate your answer in this because I want to go around the panel in this. Where do you think this case turned? We know the result, an acquittal. I'll give you mine, and you can comment on my view, and maybe have your own. To me, the second that the prosecution adopted the theory that Trayvon Martin was on top. Remember, in opening statement, the prosecutor said, that George Zimmerman was on top. Well, as the trial went down, even when remember that moment when both prosecution and defense were fussing with that dummy. Well, in both cases, they were saying that they were Trayvon Martin on top of that dummy. To me, that is where this case turned. But I'm curious to see where you guys think that this case turned.
Oh, there were several points in this case. That was one of them. That's huge. Who was on top at the time this occurred? I think the defense expert had had an influence on that. That the state, realized. I think at a certain point that they just couldn't prove their position. I think the issue with who was screaming. They were trying to use an expert, and obviously the judge, and I think rightfully so, ruled that they were not allowed to have an expert come in and say that's definitely the Trayvon screaming. I think that that's something that takes. She was absolutely right. That takes it that's up to the jury to decide. It's not up to an expert to come in and tell the jury that this is who it is. I think that there were several points, but again, putting on my hat, my prosecutor hat, one of the hats I've worn in my career, I think you take your witnesses as you find them, and you would love to have, as Chuck indicated, someone who speaks eloquently, someone who comes in and can point out in very plain, simple language what an expert does. Unfortunately, sometimes you don't have that. Unfortunately, you would love to have nuns come in and tell you that they were eyewitnesses to a particular crime. And rabbis too. And and unfortunately, most crimes are not planned or committed in front of nuns and rabbis.
Right.
So you have to take what you get, and that's from a defense point of view. Sometimes you're stuck with what you're stuck with. You can't change the facts.
Where do you think the case turned, Chuck?
Well, I like your analysis, and I'm going to kind of stick with that. And there's two things I want to discuss about that. In terms of where the case turned. I know you're focused on the trial, but there were some pre-trial strategy decisions that I thought turned this case. Everyone was talking, stand your ground. Defense attorney said, not going there, not now, for strategical reasons. And that is because, number one, the defendant would have had to have subjected himself to cross-examination, which they didn't want to do. And anybody who's prosecuted for any period of time would have known at that point. I would have known and suspected that he was not going to testify in the trial, or they certainly didn't want me to know what he was going to say before the trial. And I would have known that now my only hope, and this is why people may be faulting the prosecution on this, but now your only hope at this point is you have to introduce everything he possibly has said about this particular incident and try to shoot holes in it. That was the only strategy that the prosecution could take, and that was a turn for the defense. They didn't utilize the stand
And they
your ground.
would have had to show their hand too at
They
a
would have shown-
stand your ground
Right,
hearing.
right.
The defense
Exactly.
would have shown what they were going
Right.
to do.
Well, I think also they knew or believed that the judge would not have granted that motion because I don't think it would have been politically expedient. I think it would have been a political nightmare had she granted it. With all that was going
I
on.
think you're absolutely right about
Yeah.
that, and that's going to take me to some other issues when we talk about the horror of stand your ground. Because if a judge had granted it, right now, then the Martin family wouldn't be able to pursue civil remedies,
Right.
and now they're pursuing civil remedies. All right, and we'll talk about that in terms of the controversy of that. But the in trial aspect of it that you talked about, I think you're absolutely right about the prosecution's adopting a theory as to who was on top. And you see, even with the medical examiner who was the great medical examiner for the defense, who opined or concluded that Zimmerman had to be on top, with a rigorous cross-examination, I think you might have been able to even get him to concede that there is still, that the forensic evidence doesn't conclusively establish that Zimmerman was on top. It may be consistent with, but it also can be consistent with someone else being on top. You can't get that just from where gunshots actually penetrated from the standpoint of how close they were. And you had, granted, you may have had more than one witness say that Zimmerman was on top, but you had the one witness who said that Trayvon Martin was on top. So that was a factual question for the jury to decide, regardless of what experts have said. So you never should have abandoned the who was on top theory. So it made it appear as though now the theory was flawed. And so to me, the approach in this particular case was to cross-examine so that you could show that it was still a possibility that Martin could have been on top. Stick with the Martin still on top situation, and this whole case really boiled down to, in those 4 minutes, who was the aggressor. And if you can establish, or at least if based on all the other series of acts that had occurred before that, the prosecution could successfully argue that Zimmerman was the initial aggressor, then he couldn't take advantage of no duty to retreat, and it would have been excessive force, would have been at very least manslaughter. That means not justified, not excused. That was the whole issue. Was it justifiable? When he claimed that Martin actually initiated it and jumped on him, no one knew. And then if the prosecution should have established that's not reasonable, you can reject that. Here's why: he was the aggressor, and you don't take a gun to a fist fight. You can't initiate, even in the statutes themselves, even in the use of force aggressive statutes that you were a part of. It talks about aggressors can't take advantage of retreat, and they can't start a fight and then finish it off just because they're losing it.
I'd like to go around the room. And where do you think, Sheriff Lamberti, the case turned?
Well, taking myself out of this panel and putting myself in the environment of the public watching, I'd have to say it was the phone call. That should have been a critical piece of evidence that the prosecution put up there, that it was Trayvon's voice that was screaming. And I think they thought, well, that's going to put in their mind, identify who the aggressor was. And again, I'm putting myself in those living rooms of everybody watching. But all of a sudden, when that theory was contested,
By the two mothers
by
and other relatives.
the other relatives, the father, the mother said, no, that's my son. No, that's my son. And then when Trayvon's own relatives showed some kind of doubt in interviews with the police and interviews with the media, that they weren't 100% sure. I think the prosecution thought that was going to be a conclusive piece of evidence, and it should have been. It should have been a critical piece of evidence. Turned out, the defense shot a hole in it, and I think from the people that I talked to in the public, that put a doubt in their mind about who the aggressor was. I think when it was originally put out there that it was Trayvon screaming, that showed that Zimmerman was the aggressor. But it turned, so for the general public out there, I think that phone call played a big role.
Can I say just one thing about
Sure.
the voice thing? Because I found this to be very interesting, and I just want to throw this kind of out there. and that is the judge didn't allow experts
Right.
to render an opinion on that. But what most people don't know is that under our rules of evidence, lay people can render certain opinions. They're not supposed to. They're only supposed to tell us what they heard, what they saw. And what we say is hearsay witnesses, or ear witnesses and eyewitnesses. But in this particular case, notice she was allowing lay people, not experts, to render opinions as to whose voice that was. Now, she didn't allow the experts to do it, and I thought it was a correct ruling.
Right.
And that it's just not reliable. I mean,
But
they're
that
not there.
phone call became totally inconclusive, and that was
But
almost
wouldn't
a
the jury
rejection.
instruction- but wouldn't the jury instruction have cured that?
No.
No.
The fact, as you say, that this expert was going to give unreliable.
That's one of the reasons why we've just passed recently the Daubert test, because we want opinion expert or scientific expert or opinion testimony. It should be reliable. That should be the threshold for introducing any kind of evidence in any kind of trial, particularly in a criminal trial where life is at stake. Okay, so reliability should be the key, and I'm glad they passed Daubert for that reason. But for the layperson, and this just became an emotional battle this time. For me, I thought it was just as unreliable for even a layperson to say, "Oh, that's my son. That's my son." And it went on to the point where the judge even allowed neighbors and friends to come over and say, "That's his voice." That voice.
Well,
How often have you heard it
Indicated,
scream?
though.
Right. David, let me say that, first of all, in retrospect, having heard all of the evidence, I don't think there was anything. There legally should have been no way that this jury, whether it was 6 whites or 6 African Americans, there legally should have been no way, having heard all the testimony, that they could have convicted Zimmerman. And therefore, knowing what we know now, and the prosecution didn't know how people would testify, but which is why he was charged and taken to trial. But in retrospect, it seems clear that there was probably no way that Zimmerman legally should have been convicted because of all those things. In reference to that voice testimony, it sounded to me like what the expert wanted to do was quackery. You need 30 seconds worth of tape to reliably determine whose voice it was. They only had 8 seconds, so he wanted to replay the same 8 seconds 5 times. Well, that's ridiculous.
Okay.
That's not 30 seconds. So the judge
was
rightly rejected that. When you heard all of the evidence, what of the evidence that I'd heard that I think convinced a lot of people on the self-defense was apparently, and correct me if I'm wrong, please, Trayvon Martin did not have any injuries other than injuries to his knuckles and the gunshot wound. And Zimmerman had the injury, broken nose, injuries to the head. It gave certainly, at a minimum, reasonable doubt as to who was the aggressor. So in retrospect, I don't think there was any one thing. When you combine all of the evidence, there just wasn't enough evidence there to convict under the facts of this case.
But there were things the prosecution argued that said, even with that, their theory was that the screaming stopped the moment the shot occurred. Secondly, some of the areas where the fight he claims took place, there were no forensic evidence to support it, or the bodies were not in those areas. The body, particularly, was not in the area where he claimed that he was getting pummeled and his head was being thrashed on the sidewalk, and at that moment he shot. And the prosecution's theory was that it didn't happen there on the sidewalk. So that's what raised questions for the jury, and that's why it was probably best that this be aired out in a court of law.
And that's why it was reasonable, beyond and to the exclusion of any
Yeah,
reasonable doubt, which is why it said,
Just-
again,
just-
if Zimmerman had perished and Trayvon had killed him, legally you should have had the same result because you couldn't prove it.
Just to round out the panel, John McCrae, where did the case turn for you from your observation?
Well, I think the case was tough from the beginning. I do think that there was enough to prosecute him, but you don't need reasonable doubt, beyond a reasonable doubt, to charge someone. I said in the very beginning that this would be a tough case. Anytime you have a dead body and you don't really have any eyewitnesses to support the decedent's claim, is tough. And the way I describe it, in my mind, George Zimmerman is not guilty, but he's also not innocent. There's a difference between the two. Innocence means that he didn't do it. Not guilty means that he may have done it, but the state did not meet its burden of proof by proving guilt beyond and to the exclusion of a reasonable
And can I
doubt.
put that one way, a
Sure.
final way? A jury verdict never has on it innocent. It always has what the charge is that you can convict of, or you can say not guilty. And not guilty can be a number of things. Some jurors may feel that he's actually innocent. Some may just feel the case was not proved beyond and to the exclusion of every reasonable doubt. There's not proved, and there is innocent. But make no mistake about it, a finding of not guilty in no way establishes that a crime did not occur.
Absolutely.
David, can I bring up one kind of new topic? One of the concerns, I think that a lot of what has occurred, and I think that we need to really get into this, a lot of the people have been reacting the way they have, not just because of Trayvon, but because of a societal view of a lot of what's wrong with the American justice system. And I don't know how many people remember a young man named Martin Lee Anderson up in North Florida, boot camp. You know, a young man who actually was beaten to death while in police custody. You have a lot of real problems that I think most people, or hopefully everybody, will agree really are occurring. This particular case was not a good example, but this particular case has brought back in the memory of so many people so many other cases that were real problems that I think that we need to also be discussing, not just as a panel, but as a society, the entire race relation issue as it applies to the civil and criminal justice
Well,
system.
let me ask you a question, Senator. You represent a fairly large amount of people and
I was
covered
the minority
a
leader
lot,
of the
a lot of
Senate.
Broward County. Let's say there was this verdict, which it is, and there was unrest among the people, which so far we know it's the demonstrations have been peaceful, more or less. But let's say they were getting aggressive, the demonstrations, and you felt it was your duty to go among your people that you were representing and try to calm them down or show that you're empathetic to their feelings. What would you say to a disgruntled segment of the population that was angry about this verdict?
Well, first, I would object to the hypothetical question, but as a lawyer. But beyond that, I think, again, is what I've just said. The facts of this particular case were not a good one. I think public passion was inflamed over this case a lot. I know in my house this occurred when the pictures of a 12-year-old Trayvon Martin were splashed across the country, and everybody, I remember my wife looking and saying, "Oh, look at that poor little boy, what a sweet face. How could anybody possibly be scared?" And America got used to seeing a 12-year-old Trayvon, not a 17-year-old. I think that helped inflame the public opinion initially. But there really are real life problems. There have been too many minority, Hispanic, more African American children that have been killed, that have not gotten fair trials. This is just the wrong example to be choosing. But there are problems that really need fixing in our criminal justice system, and I'd ask,
Well,
And
other
that's a
people
good
to
way to
comment.
sort of lead towards an ending of our discussion. What can we learn from this case? How can we make the criminal justice system better and bring about some real change? We'll start off with Johnny McCrae.
Well, I think the biggest problem that I see, and I've talked about stand your ground, I've often said that it's not about stand your ground, it's about changing attitudes. And I don't think George Zimmerman, when George Zimmerman went out, he had stand your ground in his mind. I don't think when you have other folk out creating problems for certain folk because of their race, that they're doing it because of a particular law. I think that we've got to change our attitudes about race and about racism in America. I look at the O.J. Simpson case. many of my colleagues who are diehard defense lawyers were mad at Johnny Cochran because of the job that he had done for his client. And it's about race instead of looking at the issues. And I think that until we change our attitudes in this great country, I think we're going to have other Trayvon Martins and the Martin young man up in North Florida, Martin Lee Anderson, yes.
Okay. If you are you going around the room?
Sure.
Okay. First of all, I may be one of the few people in the country that actually agreed with both O.J. Simpson verdicts because, again, I'm just trying to demonstrate the high threshold in a criminal case of beyond and to the exclusion of any reasonable doubt. I believe that they didn't find him guilty beyond and to the exclusion of any reasonable doubt, which is why they acquitted him. But they did find that he probably did it, which is why he was guilty in the civil lawsuit.
That goes back to my comment where I
Right.
said not guilty doesn't mean
Exactly.
that a crime did not occur.
But I would disagree with my friend Johnny here about the stand your ground issue. I do think that that really is part of the problem. I argued against it on the floor of the Senate, and I said at the time that this would lead to a Wild West mentality. That is happening. You could literally have two guys go into a bar, get into an argument, strap on their guns, and go out, and whichever one survives said, "Hey, you saw he pulled on me," which is the old Wild West movie. I've spoken with too many judges. I've spoken with too many prosecutors who have said that you have two gangbangers going at it, and they can't arrest the survivor because both of them can argue correctly, well, the other guy was armed, I was in fear for my life. I really do think that we should change the stand your ground law, although I can tell you politically the chances that we will actually do that range from slim to none, at least in the current legislature.
And the sheriff, that anger that the cop on the beat, to use an old phrase, which you probably were yourself 30 years ago, that's out there in the public, and there are segments of the public that don't feel they're part of the system, and thus they're almost ripe for anger when a landmark case like the George Zimmerman Trayvon Martin case. What can the local law enforcement do?
Well, I agree with Mr. McCrae when you talk about how we have to change people's attitude. I mean, violence doesn't solve anything. Overreacting to the disrespect part doesn't change anything. It doesn't do anything. You don't solve any problems that way. But the one takeaway that I have, and it's something that we started, this was the perfect storm. Both George Zimmerman and Trayvon Martin were both in the wrong place at the wrong time. What started this whole thing? Zimmerman put himself in a position he should have never been put in. If there's one thing we teach in law enforcement, we have to have the community support. We can't do it by ourselves. We need the community to help us, to be our eyes and ears. But one of the things that we preach in Neighborhood Watch, in Crime Watch, in Citizen Observer Patrol, observe and report. Observe and report. You're there to be the eyes and ears. And it goes back to Zimmerman being told, hey, police are on their way, let us handle it. He violated everything that we teach in helping us from our citizen volunteers. So he put himself in a position, in a place he should have never been in to begin with. And again, we preach that. The second thing we preach is, even if you have a concealed weapons permit, you may be legally entitled to carry that firearm, and in this case he was. When you are acting as part of Neighborhood Watch or Crime Watch, you do not have any weapons with you. You do not. And so that's a second tenet that he violated. So again, this was the perfect storm, but he put himself in a position that he should have never been in. That's my takeaway, is to preach to our citizen volunteers even more so. This should be an example to them. This is why we teach that. This is why we teach observe and report. Eyes and ears. Don't be armed. Don't try to do it yourself. And, don't try to take the law into your own hands. And this reinforces for me why we teach that. Had he listened to that, he, Trayvon, and our community would not have been in that position to begin with.
Now, Chuck, you're retiring from an illustrious career at
I
the
did,
state.
2 weeks
So
ago.
you have
2
retired.
weeks ago.
So you'll have the time to work at issues in the community if you were so inclined. What can we learn from this case? And we're never going to do away with murders or even complete racial tension in this country, but we can do better. How would you lead us on the road of doing better?
Well, let me just say this: in my 37 and a half years with the criminal justice system, and it's a societal issue that we have to deal with. Most of your crimes, and particularly your violent crimes, are intra-racial, not interracial. And by that I mean it's black on black or white on white. And so when we do get these interracial situations, sometimes they do have a tendency to become exaggerated, and we go back to, well, what about this criminal justice system and how fair it is to African Americans? And one of the reasons this always happens is because there's no question across the board there's a disparity as far as the impact of the criminal justice system on African Americans. To give you an example, there was an article in the newspaper today, and it points out, and we know this is nationwide, that 48% of the people in prison in Florida are African American, whereas their population is 17%. And you're going to find that across the board nationwide. And so as a result of that, people are going to think there is something wrong or have a perception that the criminal justice system has a prejudice, would be more likely than that, and unfair to African Americans. So you get a situation like this that happens, and it's going to be exaggerated. And instead of becoming a simple criminal case, which this was, it became now a political and a civil rights issue. Now, what can we do in the criminal justice system? Well, let me just say this, and I agree with Senator Gelber that I disagree with the stand your ground law, but I don't disagree with that law because I think it creates a wild, wild west atmosphere. I don't think laws that are tucked away in Chapter 776 of the Florida statute is going to create some statewide atmosphere where people are now suddenly going to become more violent. I don't think so. I think that's just human nature in terms of violence is concerned. We have enough. I think it's our social media, it's our media and our entertainment that creates this kind of atmosphere. Just go back. My wife watches Westerns, and I watch some of those on the Western Show, and all they do is just, they settle matters by guns. It's like somebody steals something, you shoot them dead. They steal a cow, you shoot them dead. You stand up and you have a fight in a bar, and you go outside and you just stand off and you shoot and you shoot and you shoot. The sheriff has to take guns away. So, and now it's gotten to the point where technologically with games and stuff, all we do is we show violence. That's what creates violence. I have my objections with that. Stand your ground for other reasons. It's created legal havoc. It's created havoc within our court system, both in decisions that police officers make, charging decisions for investigation, charges that prosecutors have to make, even judges' decisions. We see it running across the gamut, across the board. Some of it just doesn't make any sense because they took a sledgehammer to kill a fly. They wanted to just take away the duty to retreat, and that's all you had to do. You didn't have to go and create all these other immunity issues and
really
presumptions and all of that stuff.
That.
It should be a factual. It should be a factual issue. You don't need to presume anything. But in the long run, as far as the system is concerned, until we ourselves continue and have discussions like this, until we bring to the forefront things that America perceives as unfair to African Americans and seriously discuss it, we're going to continue to have the problem. I would phrase it just differently than you, Sheriff. In this particular case, they both, Martin and Zimmerman, were in the right place. Neither one was doing anything wrong, but they were making poor decisions. They were in the right place, making poor decisions, and that's what led to the situation. And then it got all clouded and shrouded in this stand your ground problem.
Right place, wrong time.
Pedro,
Right.
Is violence or even racial tension, is it in our DNA going back to the cowboy days? Or,
Oh, yeah.
Or can we do something about it? What would you suggest?
I don't know when we turned as a country where we allow social media and the press to basically make up things to to force their agenda on the public. And this case, I think more than I've seen in a long time, from the very beginning, it seemed you had just different camps and the press getting involved in creating certain perceptions. And I think what we need to do is educate people. I mean, that's the only way we can go forward, is by educating everyone as to, find out the facts, find out what's really going on. Don't allow one particular segment of the press to tell you what is going on. I think there were reports from the very beginning that were just totally incorrect, and we find out later. I mean, quite some time later, that what really occurred in terms of some of the facts that did come out in this particular trial. I was very concerned with that from the very beginning. It just seemed that there were certain members of the press that just wanted an agenda. They were going to run over this particular person, and maybe that person deserved to be punished, but really it wasn't up for the press at that time. That's not their role. And I think there was a lot of misinformation fed, and people fed on this misinformation, and things became heated. I think, we stated earlier during the discussion, there are a lot of problems within the criminal justice system, and yes, we need more African American, Hispanic jurors. We need more minority jurors. Yes, we need more minority judges, and not because people say, well, we want more minority judges or more minority jurors because they feel that we're going to get that minority is going to get away with it. No, that's not why African Americans want and Hispanics want more minority judges. We want people who have an appreciation for our background. That's it. We want someone who's not going to sit there and say, well, that's a different person, that's a different lifestyle. I can't imagine that lifestyle. I can't imagine what they do in that community. Well, you know what? We want people who will sit there and appreciate, right or wrong, what goes on in that community. And I think that I think you need some more people in that position. And just education, just educating our youth, educating our people in general as to how our system works and why it is such a wonderful system, and why they need to get involved in making sure that our system continues to work as it does.
Well, that's a hopeful note, and we'll conclude on that hopeful note. From my point of view, when the second that I heard about this case, I felt unbelievably sadness, thinking that not one but two families are going through a tragedy. And this is a sad case. These are sad cases. They're controversial cases. No one really knew in the early stages what even possibly went on in those 4 minutes that were unaccounted for when the horrible action took place. But people did sort of have a view. Everybody had an opinion, even though they didn't have any facts to make their opinion on. But we've started a discussion about it. I hope that this will be a civics lesson for the public, and we'll have all come away learning something. So we'll just do better as a society as the months and years go by. Thank you, my illustrious panel, for allowing basically a civil attorney to sit with such important people in law enforcement.